Good morning, Ms. Hawkins.
Come on.
Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Yes, Judge. On March 6, 2025, at approximately 10:29 p.m., the officer observed a vehicle driving with expired registration as of March 2021. A traffic stop was initiated. However, the vehicle continued to travel down the feeder road until it turned and pulled onto the wrong side of a two-way road and parked facing northbound in the southbound side of the roadway. The officer made contact with the defendant, the driver and sole occupant of the vehicle, and observed the defendant to have bloodshot eyes, droopy eyelids, and a strong odor of an alcoholic beverage. The defendant admitted to drinking 1.5 alcoholic beverages, and the defendant stated she was buzzed but not drunk. An inventory search of the vehicle was conducted, and the officer found a large plastic cup that was 1/4 full of alcoholic beverage that smelled of tequila in the center console cup holder. Standard field sobriety tests were conducted, HGN 6 out of 6, walk and turn 5 out of 8, one leg stand 3 out of 4. The defendant was read the DIC and refused to provide a specimen. A blood search warrant was signed and executed.
Are you telling me that she has alcohol in the car while she's driving?
It's just getting a cup of alcohol.
Ms. Hawkins, I'm going to find that there's sufficient probable cause to go forward with your case. I am now placing several conditions on your bond. If I find that you violate these conditions, I will revoke your bond, put you in jail. No more PR bonds. Ma'am, you're not allowed to drive. I'm taking away your privilege to drive. You will be signing an affidavit with me today promising me you're not going to drive. I don't care what's going on in your life. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine. This is an affidavit that you're going to promise to me that you're not going to drive. Do you understand?
Yes, sir.
I'm also ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If I find that you're consuming alcohol or illegal drugs, likewise, I will revoke your bond, put you in jail, ma'am.
Judge, is that standard for driving?
She has alcohol in the car while she's driving. And so I would presume that it's elementary that you're not to have alcohol in the car while you're driving. It scares me, and I just don't want her driving for now.
After finding probable cause for a DWI, Judge Fleer set strict bond conditions for Ms. Hawkins, banning alcohol use and all driving. This went beyond what the prosecution requested, an ignition interlock device, or ID. While Texas law Art. 17.441 requires IDs only for repeat or aggravated DWI cases, judges have broad discretion under Article 17.40 to set any bond condition that promotes community safety. Since Ms. Hawkins had an open container in the car, the judge's actions were likely within legal bounds and not an abuse of discretion.
Understood.
We can approach at a later date, but I'm
concerned because for her employment, she can't get to and from work, and we can't get an occupational license or something like this. It's a condition of the court. I don't think we have any opposition to putting an interlock in the vehicle so that she's not able to drink and then drive. But it just seems like no driving at all seems a bit harsh for a first offense. We don't even know what the blood is at this point.
get it. But she has alcohol allegedly in the car while she's driving. One would presume that that's a humongous no-no, you know? And I want her to appreciate the privilege it is to drive. It's not a right. It's not a right. It's an absolute privilege.
Judge, if I may, what would be the conditions under which she's able to come back and get permission from the court? At what time frame?
I need to know that she understands and appreciates the privilege, you know, be proactive. It's not forever, Aaron, you know, but I want her to understand that it's a privilege, it's not a right, and it's something that people should take very seriously.
Did the alcohol?
I don't want you to talk here now in front of him. You know, you guys at a later date can come back. I'm always all ears. Like, it's not absolute.
For Greg's purposes, since he's going to be the one representing her, well, what is a later date? I mean, is there something we can do? Because, you know, if it's something that you'd like her to do while on bond to make sure that she's, you know, addressing the issue. I mean,
Be creative, be proactive. I want to know that she appreciates it, and I'm all ears, you know. But it's something that I've seen more and more, you know, where there's alcohol in the car, and I would presume that you would know, especially at this age, that, you know,
Well, to be fair, Judge, the allegation is that she violated the law. The presumption is that you would know not to violate the law, period. I personally don't think that the fact that there is possible alcohol in the car, I don't think it's been tested, but it just seems like no driving at all seems like a harsh penalty for someone who's never been arrested before, no criminal history. These are allegations. There's a blood draw pending. According to the DIM summary, she had 1.5 drinks. It's certainly possible her alcohol level comes back below the legal limit.
Ms. Hawkins' attorney asked the judge to allow her to drive to work, but Judge Fleer kept the full driving ban for now. Driving restrictions as bond conditions are separate from driver's license suspensions. Since her BAC test wasn't back yet, her license likely hadn't been suspended administratively. However, if her BAC came back over 0.08, the Department of Public Safety would suspend her license. Even if the bond condition was later lifted, she couldn't drive legally without an occupational license.
It takes 90 days to get those lab results and come back and get this taken care of. She's not driving for 90 days.
I'm not saying that long, Aaron. I just want some kind of proactivity that I know that she appreciates. Come back and,
And
Hey,
for fixed purposes, so I can convey this debate. What's proactivity to the court?
just be creative. Be creative. And, several weeks, come back and we can talk. But it's a privilege. It's not a right. And it's something that we take very seriously. Every single day, someone dies from a DWI in our county. Every single day. And we need to ensure that it's taken seriously, I'm not asking for much. And once we know that there's appreciation, then let's talk again.
On April 8, 2025, Ms. Hawkins' attorney requested a bond condition hearing. On April 10th, she appeared in court again, this time represented by her attorney of record, Greg Holton.
How's it going?
Oh, good. Thank you.
How has it been? Not tough, isn't it?
Yeah.
Sucks. Living in a city as big as Houston without the ability to drive blows. And the only thing that I'm trying to get to you is to understand that it's a privilege. It's not a right. Every single day on our streets, someone is dying from some kind of alcohol-related collision. That's what we're trying to impart to you here, to take it seriously. It's not a joke, and the last thing I want is for something like that to happen here. You understand? All right. I'll take off the restriction. Okay. What does she have now? I want to make sure that she has an interlock for now, just for a limited time.
Judge, if I could speak to that briefly,
Sure.
just to reassure the court that she fully understands the court position. I had her research and write an essay on alcohol-related accidents and fatalities. We can turn that in and take a decision-making course. Her case is a stop for expired registration, no accident. You got the blood this morning, it's a 1-3. She has no criminal history. So I would ask the court to use the research she's done in the 28 days without driving at all to understand that she gets it. And if we can not have the interlock, as would have been if she didn't have an open container, that we proceed further and let us do the work of getting the discovery move forward.
Okay.
I can turn those.
I want you to know, I will act to your lawyer, but if I find that you're using alcohol, I'm going to blow a gasket. I'm really just going to lose it. Just don't. That's all I'm asking you to do. Do you understand?
Yes.
Okay. I'll take a look at this. I'm going to acquiesce to you.
Thank you, Judge.
Just don't. Life is too short to spend the next month in a 6x9 box.
Mr. Holton informed the court that Ms. Hawkins' BAC was 0.13. Despite this, Judge Fleer removed the no driving bond condition and declined to require an ID. However, her BAC over the legal limit likely triggered an administrative license suspension. Since that issue wasn't handled in court, she would still need an occupational license to drive legally. This case shows how judges use their discretion to balance safety and fairness, adjusting bond conditions as more evidence becomes available.